Most of the Senate Republicans just blocked the passage of a law protecting access to contraception. Most Americans probably do not understand the ramifications of the Dobbs decision that reversed Roe v. Wade. They understand that the reversal allows states to pass abortion laws that would not have been allowed under Roe v. Wade and the subsequent Supreme Court decisions prior to the Dobbs decision on this issue. Roe v. Wade was decided based on the Republican and Democratic justices at the time sourcing a constitutional right to privacy in the Due Process Clause of the 14th Amendment. It was that privacy right that restrained state laws restricting abortion access. When the Republican justices reversed Roe v. Wade, they concluded that there was no privacy right in the Due Process Clause. Only the first practical application of that decision was to allow states to pass laws restricting or prohibiting abortions, which they could not have done with a right of privacy still existing in the U.S. Constitution. It needs to be understood completely that the Republican justices abolished the right to privacy. So what are the ramifications beyond abortions? There are many, but I'm going to discuss only one in this video. There is no constitutional right now prohibiting states from passing laws restricting or even preventing access to contraception devices and drugs. The entire constitutional right to privacy can trace its origins to a state ban on the sale of contraceptive drugs and medical devices. In the Griswold v. Connecticut case, the court struck down a Connecticut law that had been passed in 1879 that banned the use of any drug or medical device or any other instrument in furthering contraception. A gynecologist at the Yale School of Medicine opened a birth control clinic. She was arrested, criminally charged for violating the law, and was convicted of the crime of providing contraception devices to women. The conviction was affirmed by the higher state courts. The Supreme Court reversed the conviction in a 7-2 decision finding a right of privacy in the Constitution. Two of the concurring justices, including the leading conservative at that time, the Republican John M. Harlan II, believed that the source of the constitutional right was in the 14th Amendment Due Process Clause. That was a position that was later accepted by the 7-member majority in the Roe v. Wade decision that was decided in 1973. That decision was authored by the conservative Republican Justice Harry A. Blackmun, with other conservative Republican justices joining the majority decision, including the Chief Justice Warren E. Burger and the conservative Lewis Powell Jr. So the right of privacy, constitutional right, was first recognized in a Supreme Court decision that overturned a state law banning contraceptive drugs and devices. I have discussed this constitutional issue, which I will link in more section below. It is just important now to understand that a state can ban the sale of some contraception device or drug without without the law being overturned by the federal courts under the Constitution, because there is no right of privacy anymore in the Constitution, as the Republican justices recently held in the Dobbs decision. The contours of your constitutional rights now are defined by the Republican Supreme Court justices, by the laws and beliefs that prevailed in the 1780s when the Constitution was ratified, and that would be for federal laws. And in the 1860s when the 14th Amendment was adopted, and that would be for state laws. The Republicans call that a conservative judicial approach. So it is important to understand what is meant by conservative Republican justices now.